So I'm very pleased to introduce Dr. Stuart Baran, who's our speaker for today. And just a bit of an introduction. Stuart is a barrister at 3 New Square, which specializes in IP. He did a degree he got his PhD in chemical physics at Oxford, and came to the bar in 2011 and has practiced at 3 New Square ever since in the area of IP. He works in all areas of IP, but has a preference, I suppose, would that be fair, for trademarks and patents? That's where he specializes. He's appeared in all the different forums that you can imagine, or fora, or IP fora, including the EPO, the UK IPO, the EU General Court, and the Court of Justice of the European Union, as well as the High Court here, the Court of Appeal, and of course, it goes without saying, the Supreme Court, given what you're going to talk about today. And he's also a standing counsel to the Comptroller General and gives advices to governments on issues of IP when called upon to do so. So he's going to talk to us today on SkyKick in the UK Supreme Court. Is the sky a limit at all? And so I'll let you just get on. Thank you.
Thank you very much, Jennifer, and thank you all for having me back. It's a pleasure to talk to you about another extremely interesting and difficult Supreme Court appeal, pretending that that's where all of my practice is. This time, it's all in the context, of course, of trademark law. And before I get started with the case itself, there are a couple of slightly boring disclaimers. So first, although as Jennifer mentioned, I am one of the standing counsel to the Crown, I am counsel to the government and the IPO. My involvement in this case wasn't in that capacity. I was acting for SkyKick as a private representative. And more importantly, the government are always horribly keen for me to emphasize that these are my views and not theirs that I'm expressing today, mine alone. And also, I should say, I acted for SkyKick in this litigation, but, and this is particularly important because of the settlement the parties reached, I'm not speaking today on their behalf either. So sadly, all these views are ones for which only I am responsible. And second, I appreciate we've got quite a mixed audience today. Some people who will be intimately familiar with this judgment in all of its gory detail, and others whose experience and interest is maybe focused elsewhere or who are newer to it. So we absolutely are going to engage with the difficulties and the complexities that come out of this judgment. But to begin with, I am going to take some time just to lay out the story, and I hope that those of you who know it very well already will bear with me as I do so. Saying that, finally, it won't have escaped the notice of anyone who's read this judgment that it runs to 175 pages. So if I stood here and just read it out, that would take me, with no analysis at all, well over my allotted time. So I'm shamelessly going to be island hopping today. We're just going to pick out those bits of the case and the judgments relating to bad faith applications in particular. I'm not going to spend any time on the infringement case, on the procedural fairness, or the Brexit part of the judgment, although I'll show you where they arose. In the first two of those cases, it's because they're not very interesting in context. There's no new law. As to the Brexit points, well, those could have been a lecture of their own. So I'm not going to deal with those or the pretrial reference or the questions about when the Supreme Court should give judgment in a settled case. So we're going to focus on what I've thought of all along since I was involved with this dispute at the beginning in 2016 as the meat of this judgment, really, which is the law on bad faith and what that really should mean. So by way of an overview, now I've got the excuses out of the way, let's dive straight in. The plan roughly is as follows. I'll start by telling you a bit just about the brands and the businesses whose conflict started all this off back in 2016, as I say. More about that initial meeting later on. And the marks and the signs that were subject to the conflict, we'll look at them very briefly. Next, a bit about the shape of the dispute, what the arguments were and why to some extent. We'll start with the trial and what happened at first instance, then to the CJU, and then the Court of Appeal and the Supreme Court. We'll spend a bit of time on the application for permission to the Supreme Court, which we will look at, followed by what the parties each argued and what the court decided. And then finally, a few minutes on the interesting bit, I suppose, which is, where does this leave us? It's an enormous judgment. Has it actually changed anything? Will it, in reality, change how trademark applicants behave in this jurisdiction? And after the CJEU's judgment in this case, could anything the Supreme Court say ever have changed what applicants were going to do? So, the brands, we can take this very, very quickly. It sort of explains itself, really. Sky, I expect most of you have seen that sign somewhere around and about in Cambridge and in your daily life, wherever you are, pretty much. SkyKick, less so, but those are the signs that each of the parties were using. There are 5 trademark registrations, as we will see in a moment, but they were different specifications, all of them for one or other of those 2 signs, okay? And in SkyKick's case, there was no registration here that was relevant. It's just a case of those other signs that they were using, which were said to be an infringement. So you can see there are obvious points of similarity, and there are obvious points that would be relied on for the purposes of infringement in terms of the sign and the mark. There's not very much interesting to be observed about that. The real dispute was always going to be about similarity in terms of the goods and services, and which goods and services they should be allowed to rely on. So before we get to the specifications of the trademarks, we should talk about what these businesses were, and that becomes important later on because we're going to be measuring specifications up against that, and also because it helps us to understand why did they care enough to want to have a fight about it. So Sky, I don't need to say too much about it, I don't suppose, because it's an enormous company that many of you are already familiar with, I'm sure. It started out as a satellite TV company, which gave it its original name of British Sky Broadcasting, then became B-Sky-B, and then Sky. These days, it's a much broader business than that, also being a major provider of telephony and broadband internet. There was a great deal of evidence about all sorts of subservices and allied products that Sky offered to their consumers, but I think it's fair to say that that has always been, for material purposes, the core of their business. And for the purposes of extended protection infringement under Section 10.3, it was common ground between the parties that Sky had a reputation for those 3 heads of business, the core services. So SkyKick, the one you probably won't have heard of, it was a pretty modest startup when all this began. Originally, this was going to be a case in IPEC that I was going to have to do on my own because we couldn't really justify getting anybody else involved, because it would never go any further than IPEC because there obviously wasn't enough money in it, and we couldn't really run any difficult points or anything like that, could we? As you can imagine, now 7 court hearings later, having been to Luxembourg, the Court of Appeal twice, the High Court 5 times, and the Supreme Court, it looks a little bit different. But that's how we saw it at the time, because then they were just a modest startup. It was started by 2 former Microsoft employees, and they devised what they called a cloud-based migration system. And it was all about when Office 365, a subscription-based ability to use Office products, started in sort of mid-2010s. And what it allowed businesses to do was to migrate their complete business's set of email data for all their employees and users to the new Office 365-based system in a matter of hours. And the evidence was that at the time, that was a real advance because it replaced the tasks that even IT professionals would mostly be doing manually over the course of days and sometimes weeks. So that's where the business started. And by the time we're mostly concerned with, there was also a cloud data backup service offered that became relevant to infringement. Another key aspect that we should dwell on before we go past these to the specifications is that SkyKick didn't sell directly to the public as end consumers. Their sales were to businesses, and they were sales through what they called Microsoft partners, who were effectively IT professionals and IT consultants and so on, who were handpicked and approved to be people who were going to sell this on. As you can imagine, we relied on that pretty heavily, as saying a likelihood of confusion was inherently less likely, given how skilled and how much attention would be paid by these professionals. So next, Sky's trademark registrations. 5 trademarks were pleaded by Sky when they asserted trademark infringement. 4 were European trademarks, because this all predated even the referendum, never mind our actual departure from the EU. And there was 1 which was a UK national trademark registration. Now, that distinction isn't particularly important for anything that we're discussing today on the bad faith side, because all the law, for the purposes of this, is the same. But the distinction certainly was important in the case as a whole, very important to the Supreme Court particularly, and there were some very difficult questions about what relief the Supreme Court was able to grant in relation to the EU trademarks, given that it was considering matters in 2023 and 2024, long after we'd departed. I said we're not going to go into that in detail, and we're not. The spoiler is, essentially, the Supreme Court can continue to deal with it as if we were still in the EU, because it was an EU trademark court in which this action was started, and so because it was started before an EU trademark court, all of the appeals were carried on in the same vein, and so it enjoyed the same jurisdiction to correct, if we can put it that way, the relief that it would have done if we were still in the EU. The key and quite startling point about the registrations that were relied on is the one at the end of the slide there. They were enormous. These specifications, we used to take a paper copy to every hearing and theatrically thump it on the desk during the middle of somebody's speech, because they sought to register thousands and thousands of heads of goods and services. And it wasn't what anybody could sensibly describe, nor did they try, as a series of increasingly specific descriptors of goods and services that Sky were in fact selling, or were likely to. There was a great ragbag of more or less everything you could imagine. And that's important. Sky, equally important, they originally pleaded infringement of every single item in every one of these specifications. They gave 7 pages in their pleading generously of sample goods and services, but they said that was without prejudice to the fact that we infringed the lot. There were some terms that obviously related to what Sky actually do, though, and at trial, eventually, a story we'll return to, after much pushing from us, Sky limited themselves to a top 8 here for their infringement case, and here they are. All I'll say at this stage is you'll see that some of those terms, most obviously the first, are extremely broad terms in terms of what they cover. They could potentially be infringed if construed at their full literal width by an enormous array of different businesses' activities. I said before that Sky hadn't limited themselves just to things that related to their actual business, and in all the hearings we had lots of fun with some of the more colourfully outrageous examples here. I think we might all be slightly surprised to see any of these things being sold by the same person who had installed our broadband internet or our satellite television, but there they all were in the specifications. And that very last point there is very important. Sky wasn't just letting these things it had no proper interest in sit on the register, dormant, and not doing anything with them. It was actively enforcing them, marauding around the trademark registries, squashing small businesses who dared to sell Christmas decorations, fire extinguishers, actual examples we had. There was evidence before the judge, led by Sky, extraordinarily enough, of some 808 enforcement actions by 2016, the time of the trial, that they'd taken. And Sky's barrister even put it in cross-examination that this was an enforcement record of which any business should be proud. So the shape of the dispute at trial was this. There was a section 10.2, similarity-based likelihood of confusion case. There was a section 10.3 case, extended protection infringement for marks with a reputation. There was also some discussion of an own name defense, which led to a pre-trial application for a reference to the Court of Justice of the European Union. To deal with that very quickly, because it's another rabbit hole we could disappear down for an hour or 7, what we had said was, when the EU trademark regulation was amended in 2015, they amended out the own name defense for corporate entities. That was without a transition period, without any saving provisions. It just had immediate guillotine effect. And we argued that that was an interference with all sorts of property and fundamental rights without a transition period, and should therefore be the subject of a separate referral to the Court of Justice as to whether that aspect of the 2015 regulation was itself ultra vires and unlawful. We didn't succeed in that application, not because the court said we were wrong about it at that stage, but because the court said it would be better to decide if this needs to be referred once we've actually got the facts of the case sorted and we know whether it really matters. So that was a pre-trial outing that we all had, and the own name defense based on honest practices, and there was lots of evidence led about what advice SkyKick had, how much of a clearance search they should have done, had done, hadn't done, all of the rest of it. But that took up a lot of time at trial, but as the debate has shaken out over the years, hasn't really remained an aspect of it because of the findings the trial judge made. There was also passing off, running the alternative to trademark infringement. And then on validity, we counterclaimed on two bases. Bad faith and the extent of the relief is what we're going to be dealing with for the rest of today. And then there was also a clarity and precision objection, which we'll get to in context as well when we look at the referrals to the Court of Justice. So just to introduce what bad faith is about, Section 47 of the Trademarks Act 1994 provides that a trademark can be invalidated if it doesn't comply with one of the registrability criteria set out in Section 3. That's a paraphrase, those aren't its words. The one we're interested in Section 3, is Section 3.6, which is simple to read and so almost certain to be difficult to apply. We'll get there in due course, but just as a generalized idea of where the EU law had got to on bad faith, here we are. We have there the UK Supreme Court's paraphrase of a central holding from the CJEU in the Cotton case. And it's all about that the motive or intention of the applicant was to engage in conduct departing from accepted principles of ethical behavior or honest commercial practices, having regard to the purposes of the trademark system. So there's a sort of a moral aspect to it, if I can put it informally that way, but it's also all in the context of what trademarks are supposed to do. It's not just standing back and saying, is this something that people would think was being up to no good? But we'll examine both of those aspects as we go through. There are broadly two types of bad faith case. These also are listed in the Supreme Court's judgment when it summarizes the Cotton case. That's a very important CJU judgment that came very shortly before the SkyKick one. The first are what we sometimes call the pinching cases, when, for example, A knows that B is just about to start a business selling widgets under the name XYZ, and so A goes and registers XYZ for widgets purely to block B from getting it, knowing that he or she wants it. These are quite easy to deal with, really. Even without much understanding of trademark law, it doesn't take much imagination to see how that would be said to be applying in bad faith, and to see that it's something the law would probably want to discourage. The second set of bad faith case, perhaps a bit more subtle. Here it's where the application was made with the intention of obtaining, without even targeting a third party, a specific one, an exclusive right for purposes other than those falling within the functions of a trademark, and in particular, the essential function. So here it's the bit that's more about a recognition of trademarks' economic role in a free, competition-led market, and about promoting that. The CJEU has for many years been very fond of the concept of trademark functions, and here they seem to accept or to suggest that those recognized functions comprise the universe of things for which you could properly want to use a trademark. And so if that's right, I suppose it follows really that using trademarks for something other than that could be said to be in bad faith. So that's just a sort of a primer on roughly what we're talking about when we're talking about bad faith at this stage. So the trial was heard before Mr. Justice Arnold, as he was then, and to cut an already extremely long story very short, he found that there was no passing off, no extended protection infringement, but that there would be Section 10.2 infringement, a likelihood of confusion, if the marks were valid. A cynic might observe that that's the only combination of findings that actually makes a reference to the CJEU on this point the judge was very interested in necessary. Happily, I'm not a cynic, so I would never make such an observation. But the references went ahead on validity, and I promised I would explain this first one when we came across it earlier. So this was based on the IP translator case that went before the CJEU many years before, referred by Geoffrey Hobbs, who was sitting as an appointed person under our Trademarks Act. This reference, in the context of SkyKick, this was focused on terms like computer software, the really broad terms. IP translator itself was a case about registrability, what you could put on the register in the first place. It wasn't about infringement or validity considered after registration. But we sought to argue that the logic of it meant that it must apply to this extent too after registration, because terms such as computer software lacked precision because they were so variable that they couldn't fairly be used on the register to denote the boundary of your property right. Because we observed, a registration for computer software could be said to be infringed by almost any modern appliance, whether that be children's toys, cars, dishwashers, or the Large Hadron Collider. If you've got a registration for computer software, a business dealing in any of those will infringe it. And the idea that one business could have a need to cover all of that was innately absurd, we said, and it couldn't ever be justified to mark so very much as your own territory. And then we had the reference on bad faith, which is our focus today. So off we went to the CJEU, Mr. Justice Arnold having referred 5 questions. So the first one is that IP translator one. Essentially, the judge agreed with us that computer software was too variable if this ground was available. But he doubted that it was available because it had all been decided in the context of a registrability case. Question 2 just follows on for it and says, specifically, computer software, this is just a way to try and pin the Court of Justice down because they are absolute demons for not answering the question that you're asked. So if you ask a specific question within the broader principle question, it's harder for them to ignore it completely. So referring courts routinely do this now and will follow a broader question that they want and need the answer to with a specific one that makes it harder to avoid the first one because otherwise you just never know what you're going to get back. Questions 3 to 5 are all on the bad faith issue. Question 3, the central point in this case. If you're applying to register a trademark without an intention to use it in relation to the specified goods and services, is that enough to invalidate it? Given that you've got a 5-year grace period in which to make actual use, is it enough to say they didn't have an intention to use it in relation to the goods and services at the time of applying? Question 4 then says, well, can you have half and half? Can you be partly in bad faith? There was some UK law, Lord Walker, as he later became, when he was a first instance judge, said, I just don't really understand this partly in bad faith business. If you're seeking an application in bad faith, if you're making an application in bad faith, it's in bad faith. You don't say it's, well, you were fraudulent except that little bit of the application form where you wrote your name correctly. You just say, that's it, was how he put it. But that's not really how it's evolved in the law of trademarks so much. But there was an open question about what partial bad faith could mean and whether it was real at all. So is it possible to be partly in bad faith if you have an intent to use in some of the specified goods and services only? And of course, the implicit question in that is then what do I do about it? Do I strike through some of the goods and services? Or do we say, well, you made an application that was too broad, so you lose the application? At what level do you mete out the consequence? Finally, number 5 is related, but a slightly technical question. Section 32(3) of the UK Trademarks Act requires an applicant to state on the application form, in the form of a statutory declaration, that they do in fact have a bona fide intent to use the trademark they're seeking to register on the goods and services for which they're seeking to register it. Lots of jurisdictions subject to the same trademark directives did not have such a provision in their domestic law, and so the question was sort of allied, as you can imagine, to question 3, is it okay to ask that? And the implied second part of the question is, and so what? Because we said, of course, well, they ticked the box because they had to tick the box when they didn't have an intent to use. So we said, not only are they in bad faith because they have no intent to use in relation to great swathes of this specification, but they also lied about it on the applications. And so the question is, well, does that matter, or is it all just a bit of an ornamental provision anyway, in light of the directive? We got very excited when we had the opinion from the Advocate General to the Court of Justice, who was highly critical of what Sky had done, said essentially something must be done, and we need to find a relatively creative solution to it because the law of bad faith hasn't really been edging that way in the recent judgments that we've had. One thing that we'd suggested was to use the provision in the regulation that stopped registration of marks that were contrary to the public interest. Normally, we've thought of that as being the mark itself is contrary to the public interest. There's some broader reason why you shouldn't be able to register that, not offensive or descriptive or so on, because those are already provided for. But because there is, for some reason, some broader reason why that shouldn't be the subject of a trademark. And we, just because we were looking for somewhere to put this argument, essentially, we said, well, look, it's obviously contrary to the public interest to be allowing this to happen. So if you think it really doesn't fit in the normal scope of bad faith, well, maybe you say it's not in the public interest to allow them to register it, and that is how it doesn't fit. And the AG seemed relatively keen on that. He was certainly very, very clear that what Sky had done was not acceptable and shouldn't be allowed to go on, and that somewhere in the law, and he laid out a series of alternative routes, the CJEU needed to say it wasn't okay. But the CJEU bottled it and said a lot less. So they didn't disagree in the sense of analysing it and saying, well, you know, the AG said this, but we don't agree and this is why it doesn't work. We just got a much more vanilla judgment than anybody, I think, whichever side they found themselves on, was expecting following the AG's opinion. So the judgment itself was a little bit of an anticlimax for lots of people who were watching this case, I think, after the AG's opinion, which had seemed relatively incendiary and had made lots of people very angry, just as it had made lots of people very happy. Whereas the CJEU's judgment was much more muted and just didn't engage with an awful lot of these ideas. The central question for them remained whether the trademark had been applied for some purpose other than the proper purposes of a trademark. That's my paraphrase, that's not their wording. We'll see their wording in a minute. In fact, there it is. If the applicant for the registration of the mark had the intention either of undermining in a manner inconsistent with honest practices the interests of third parties, so that was our first limb, the pinching cases that we talked about, or without even targeting a specific third party, an exclusive right for purposes other than those falling within the functions of a trademark. Just to tell you what the answers were on the other 3 questions. The answer to question 1 was no, so our IP translator point was dead. So question 2 didn't arise. And the answer to question 5 was essentially, well, do what you like. Knock yourselves out. If you want to have the provision, have your provision. You don't need to have it. And sure, it can be evidence, you can rely on it, and the National Court can make of it what it will, but we're not terribly excited about it, was the general mood music on question 5. So we went back to Mr. Justice Arnold, and as usual, following a CJEU judgment, the judgment was so clear that both sides claimed emphatically that it meant they had to win. And where we ended up was with a considerable amount of bad faith being found by Mr. Justice Arnold on that test. He said, well, look, they are doing this for reasons other than the proper reasons for getting a trademark. He trimmed back their specifications, removed some of the goods and services by quite a considerable degree, actually. In some cases, that wasn't just by simple deletion, that was by rewriting some of the terms to make them narrower, reframing them to essentially give them the maximum good faith specifications, if I can put it that way. And we'll turn to that at the end. But he still found that there was infringement even after he'd cut the specification back of the terms that were properly left behind. The judge ended up giving 4 judgments in total, given all the various spats about the form of relief and the wording of injunctions and so on after going to Luxembourg. And none of this was helped by the fact we were now fully in throes of the pandemic, and so some of these hearings were on paper or virtual and what have you. But once all that was done and the final order was made, we were off the Court of Appeal. On the grounds there, so SkyKick, predictably enough, said that the judge was wrong about infringement and that he should have gone a bit further in relation to bad faith, so that there was nothing left behind that we could have been said to infringe. Meanwhile, Sky cross-appealed and said the judge was wrong to say no passing off and wrong to say that there was no extended protection infringement, and that he'd been wrong to invalidate anything at all because on the CJEU's judgment, they couldn't properly be said to have been in bad faith in any respect, and they should still be allowed their full restored specifications. Following a 3-day appeal in 2021, the Court of Appeal gave judgment, and it didn't make for happy reading for those of us acting for SkyKick. We always knew this was a difficult case, and we were entirely open to the possibility that the court might not see things our way and that we might come second. But it's fair to say that the extreme terms in which the Court of Appeal judgment were written were genuinely shocking to us. Essentially, what emerged was an all but unmitigated approval of everything that Sky had been doing. The overall tenor was that Sky was a big company with a large business, and so that, of course, justified it claiming very broad property rights. Importantly, the Court of Appeal thought there was nothing wrong in the breadth of a term, provided that somewhere in that term was something you had intended to use, then it was fine. You could use whatever general descriptor you chose, as long as it was a general descriptor that applied to the thing you had done. So if what you intended to sell was definitively limited to armoured military tanks of a single size made exclusively of reinforced steel, then a trademark registration to vehicles was not only available, but unimpeachable, especially if you were a big business. On passing off an extended protection infringement, the judge was upheld, so those 2 claims were found rightly to have been dismissed. So where did that leave us, apart from upset, after the Court of Appeal? Well, at this point, bad faith has really been cut back in its ability to be deployed as an invalidity attack. We're left with those pinching cases where the facts show effectively some deliberate misbehaviour. Or alternatively, the seeking of registration of terms where there's no use intended of any part of the term at all. Applying to register, as I've said there, microwaves when you only intend to sell leather gloves. That was definitively bad faith. But using a term that was vastly broader than what you intended to do, as long as what you intended to do was in it, would be fine. Now, especially considering how extreme the Court of Appeal's judgment had seemed to us, we were straight away considering an appeal, and 3 problems in particular struck us with this view of trademarks. First of all, the point of a trademarks register is to tell the public what they can and they can't do. That's a slightly oversimplified way of putting it. It's to help them to evaluate the risks associated with things they may or may not choose to do, at a minimum, I would say. That's a central purpose of the register, and therefore a central purpose of the office. All of the statutes lay out that the office must act to maintain a register, and the Controller General, who is the Registrar of Trademarks, as well, has a whole series of express statutory duties in the maintenance of a register, and may even be liable in breach of statutory duty, I suppose, were he or she not to fulfill those duties. But a register that tells you that this business needs to fence off this enormous great swathe of business activity when in fact they're only selling those military tanks we mentioned, or the leather gloves, or the whips, or whatever it is, that's not really telling the public something useful. It's telling the public you're at risk of bumping into someone without fairly competing when that's just not right. It leaves a lot of clutter in a different sense from the normal way in which that term is used about trademark registers. It leaves a lot of cluttered space where you're effectively misinforming the public about where the no-go areas are. The breadth of terms, completely unchecked. So on the face of it, there's no incentive to have any serious thought about, well, actually, what is the scope of the business I want to carry out? What's the biggest possible term? What's the most general and uninformative term I can use that would encapsulate things I want to do? Is the obvious way to go as an applicant following this judgment. So we sought permission for a further appeal. And as many of you will know, except in the absolute most urgent cases of life and death, the Court of Appeal basically never grants permission to appeal to the Supreme Court, and you have to go and ask the Supreme Court themselves. But you have to ask the Court of Appeal, and you have to get them to refuse it before you can go. But that's what happened, and off we went to the Supreme Court, and we had to appeal enough points to ensure we had a route to victory overall, right? You can't just pick the interesting ones. You've got to make sure that you have got a route to say the order shouldn't have been made. So we needed to remove enough of the specification that we could no longer be found to infringe, but certainly the core of the case, the message of the case, was always going to be about the scope of bad faith invalidity. And we picked out this problem in particular that showed not only was the Court of Appeal's approach rather extreme and pretty problematic at the level of principle, but it also led to some results in application that were obviously absurd. So if you imagine a specialist software company that is only intending and will only ever sell software for motor vehicles. They've got a tie-up with a motor vehicle company, and that's all they're intending to do because they've got a background in the motor industry, and that's what's got them into it. They are not intending, they are absolutely dead set, that's what it is. So they're intending to do software for motor vehicles. If they apply to register software for motor vehicles, computer software for accounting, then that term will be in bad faith because they don't intend to use it. They won't be entitled to a property right that covers, in that way, computer software for accounting. If instead they just write computer software, which includes computer software for motor vehicles and for accounting and everything the hell else, then that's absolutely fine. No bad faith at all. It doesn't make any sense. And so we put this front and center in our application. You only get 10 pages when you apply to the Supreme Court. And it would be remiss not to mention, and I don't do that just because of where I'm standing, that our permission to appeal application attracted some support from notable academics in the field and some names, as you will see in a moment, that you recognize. These sorts of interventions have typically been sought by putative applicants to the Supreme Court in IP cases, and they often really help to sway the justices on the question of whether or not to hear an appeal. But typically, they come from a trade association. In a patents case, you might consult an association of R&D-led pharmaceutical companies or of generic pharmaceutical companies, depending what side of the argument you're on. But of course, in a trademarks case, there is no association of alleged infringers, so that wasn't really open to us. We became aware that some of our academic colleagues were interested in the case and might consider intervening. Now, of course, to a lawyer, that is, and I say this for the most respectful of reasons, quite a scary prospect. Because, of course, if you contact the Pharmaceutical Patent Holders Association in your patents case, you can be pretty confident their position is going to be the one that aligns with pharmaceutical patent holders. But if you ask an academic, you know that so much of the value that they bring inheres in precisely the fact that they are independent of defined interests like that. So you don't know quite what they might think or say, and you don't know if they agree with your case at all or partly, or on the convenient bit or the bit that you need to win in order to get the relief you want. And it would be grossly inappropriate to suggest to them what they might think or say, both as a matter of simple respect for their important academic freedoms, but also in terms of then being able to say to the Supreme Court that their views, if they do turn out to be favourable to your side of the case, are valuable and should be heeded because they're truly independent. As it was, 2 interventions from our academic colleagues were submitted on permission to appeal, and we were very happy to discover what they thought and what they said. Though the first was David Vaver, the 2 or 3 chairs of IP back in Oxford, who described the Court of Appeal's decision as particularly anachronistic, for the reasons that you can see at the bottom there. And then, from some other people you might recognise, a fundamental error. The approach supported by the Court of Appeal puts the costs of all of these difficult and abusive acts on all the wrong people. This cannot be right and is inconsistent with the purpose of Section 32. So it was that we received notice that we had been granted permission to appeal. What case did we run? Well, these were the key points. First, predictably, that Sky's conduct was bad faith because it was seeking protection other than for a proper trademark purpose, and you had to have regard to the full purposes of the trademark system when evaluating that. The High Court had made central findings of deliberately framing overbroad. The judge had found that it was used purely as a legal weapon that justified Sky's strategy. He found that they had a strategy of claiming overbroad without regard to the legal or commercial rationale for doing so. Essentially, getting rights because they were there and because they could. We said that the Court of Appeal's use any of it and you keep it all approach to broad terms was wrong, that they should delete the offending terms entirely, or at least rewrite them in the fashion that we put forward. Then there was a series of points on procedural fairness, the Brexit point, and on infringement, which we won't concern ourselves with today. Sky's case, well, they said, well, look, the Court of Appeals correctly summarised the principles of law. SkyKick hasn't applied to depart from EU law. And the analysis should only be of those top 8 sets of goods and services. All of this talk of whips and bleaching preparations and Gladstone bags and all that stuff, it's all irrelevant because they didn't like hearing it, as you can imagine, much as we enjoyed going through it far more often than was really justified. There's no requirement for an intent to use at the application stage, they said, and that had to be so to give a useful effect to the 5-year grace period for use. They said if effectively you've got to have set up your use and proven it in advance for the 5 years, it's not really a grace period at all, was their position. They said that effectively the UK courts were miscreants who had never really listened to the EU courts on bad faith, that it had been clear all along that bad faith was supposed to be limited, and the UK just didn't agree and kept grumbling about it, and that this doctrinal disagreement with that approach was destabilising and wrong. I don't think that's really a fair characterisation of what had happened in the UK courts, but it's something they said in their written case. In terms, they said bad faith requires a lot of dishonesty, a sort of dishonesty that hasn't been established in this case. There was an awful lot of pearl clutching about how dare they say we're acting in bad faith, isn't it terrible? Imagine the shame brought on all of our employees. And the answer was, well, look, this isn't some sort of objective moral condemnation. This isn't a criminal case, nor is anybody pretending it is. We've all said, and we've said all along, that bad faith is in the context of the trademark system. It's all about, are you doing something that comports with the purposes of the trademark system and using that properly? Indeed, we relied specifically on a doctrine of EU law called abuse of right, abus de droit, which essentially, those of you who are better representatives of Generation Z than I might call the doctrine of malicious compliance. It's to say you can do something that falls entirely within the rules, but when you're clearly doing it to take the mickey out of the rules, or to seek an advantage the rules were clearly not there to grant to you, then it's no defense to say, but what I was doing was within the rules. There's all sorts of applications of that across EU law, in tax, in various aspects of commercial law. And we said, look, it's a perfectly sound doctrinal basis for explaining why it shouldn't be a complete answer to say, well, I applied for the things I'm allowed to apply. And I don't need to have used them yet. They also said, because they had to, really, there was no reasonable basis for the purely illegal weapon finding. The registrar also appeared at the hearing. We on SkyKick's side came to think that actually this was pretty crucial. They're not crucial in advance, but what the controller actually said at the hearing, obviously it wasn't me, I wasn't allowed to do it. My colleague Anna Edwards-Stewart appeared for the registrar. And they said there are 3 aspects of the Court of Appeal decision listed there that restrict, on the face of it, bad faith attacks. And they said, look, we've actually got to maintain this register, and we're the ones that have got to decide what goes on it and doesn't. So we need some clarity here. If there is this great doctrinal disagreement and these miscreant judges that the other side, that Sky have been talking about, well, we need it resolving. And we think that, at least on the face of it, some of the problems that SkyKick are dreaming up, some of them are real. And so we don't really mind what the answer is, but we do need to know what the answer is, which is often the position that the registrar appropriately comes to a case with, because they're not there to swing in as a partisan. They're there to say, we just need some help and we need to know what we've got to do. So really, they're there seeking clarity. The collected principles were brought together then in the decision of the Supreme Court that arrived last November, nearly 18 months after the hearing. But when you read it, it became a bit clearer why that might be. Bad faith might in real life mean dishonesty, but here it's all in the context of the trademark system. We've seen the 2 limbs of the CJEU test set out in Cotton. You can make out bad faith under either. It's not to be limited to pinching cases. The subjective intent of an applicant can be established objectively. And then an important one for us in this case about the burden. The burden of establishing a bad faith attack starts with the party that's looking to have the mark invalidated. But if they establish a prima facie case, the burden shifts, and it's for the proprietor, the applicant, then to give a plausible explanation of their objectives and commercial logic. Registration without any intent to use is bad faith, where there is no rationale that comports with the trademark law, and the assessment requires objective, relevant, and consistent indicia. I think those last few principles I can just leave there. There's no point in me reading them out slower. Those are the things we've just been talking about, essentially. Abus de droit is a sensible basis. The absence of an intent to use in relation to just some of the goods and services means you just cut back those ones. And that was the answer to question 4 from the CJU. We'll talk about that in a minute, because lots of people are saying, well, obviously that had to be the answer. That was always going to be the answer. I think it's an answer that's manifestly stupid in lots of ways. And so we'll talk about it shortly, why. It was inevitable that it would be expressed that way, but in its actual effect, it's clearly not what anybody would have intended. This one, no requirements under the trademark directive. So this is just the question 5. This is section 32.3. Okay? No requirement in the European law that you make a positive statement of an intent to use. But since you've been asked to in the UK, if you tick the box, that can be evidence. But frankly, I don't think it will ever be something that sways the case. Because it's only the evidence that shows that they've wrongly ticked the box that's actually going to sway the court, if you see what I mean. I don't think the ticking of the box adds very much, really. It's something you'll make noise about and say, well, they've made a statutory declaration that's false, but I don't think it really adds very much. And I think that's realistically where the European law has got to, and that's rightly noted by the Supreme Court. But they said, as to goods and services with no prospect of use, the Court of Appeal had been too permissive, and they were persuaded by the abus de droit idea that this malicious compliance with the rules was perfectly possible. The registrar's example of someone who applied to register a trademark for all goods and services in all classes helped to show this, because the mere fact of having done so meant it was so prima facie unlikely that they had an intent to use that the burden should shift. Even without more, such an extreme example serves to show that you can look at that and say, hang on a minute, and that's a perfectly valid way to approach it. So sheer size can rebut the presumption of good faith, but of course, the applicant then has the ability to say, no, I really do intend to use substantially all of these things, and here's the material that substantiates that intention. Finally, having a reputation, being a big company, doesn't allow you to apply broader than your intent to use, because you've already got extended protection infringement because of Section 10.3. You don't need a penumbra and then another penumbra and then no, it just gets out of hand if you're not careful. Broad categories. Overly broad terms can be bad faith, even when there is some use within the term. The registrar had said, if this is to be an objection, it needs to have teeth if it's to prevent the cluttering of the register. Namely, we need to be able to do something about it and refuse registrations to some significant extent when this occurs, or cut them back. The UK Supreme Court said, well, I can put your minds at rest. It does have teeth. So the Court of Appeal had not approached things correctly in this respect. In my view, and for the reasons which follow, the judge was entitled to find the judge at first instance. That means that the applications were made in bad faith in the way he did, and to require the modification of the top eight that we saw in the way that he cut them back. The Court of Appeal's any use in the term will do was in clear error, because it would be manifestly unjust if you could escape the consequence of bad faith simply because you framed your specification using more general and less informative words. Those are the errors made by the Court of Appeal. Failed properly to appreciate the scope and component elements of the bad faith objection. Use some and keep all was wrong. Second, the judge in the High Court didn't make any material error or omission that the Court of Appeal should have reversed. And third, the Court of Appeal failed to take proper account of Sky's conduct, effectively. First of all, the fact that they relied on the entirety of those enormous specifications all the way until right before trial. Second, that they were themselves hugely broad and already raised a perfectly sensible suspicion. Third, that the selected goods and services, that's that top eight, were only crystallized at the time of closing arguments in the trial. So the ability to respond to those, frame the cross-examination around them, and so on, was limited by the way that Sky had brought its case. And that Sky obtained, and not just obtained, but then actually brandished these legal weapons as Mr. Justice Arnold had found them to be, even when they had no intent to use. They'd enforced against companies wishing to sell things they never intended to use themselves. So where does that all leave us? SkyKick broadly succeeded on the big legal issues, doctrinal issues, but it was decided that there was still some infringement of one of the terms that remained. That, of course, was a part of the judgment that's entirely crucial to the parties and for the determination of any relief. But it's not of much legal significance. There aren't any new principles laid out there, so we leave it aside for today. So it was a sort of score draw, really. And in the event, the parties settled, SkyKick having just been bought out by another entity that wanted to draw a line under its dispute with Sky, and that was right before the judgment, and there's mention of that in paragraph 12 of the judgment and the consequences of it. The Supreme Court went on to give its judgment anyway, given the importance and breadth of the issues, and the controller's request for clarity to help with the examination of future trademarks. But the parties were no longer fighting the same way they had been. So just to finish, I want to step back a bit and ask where this has left us. Since those of us on the SkyKick team successfully got this conduct applying overbroad without relevant intent to use recognised as bad faith, that ought to put a stop to it, you would think. But I fear it won't. And that, I should fairly say, the bit of the law that I say that actually has some effects that look quite stupid, none of that's the Supreme Court's fault. The blame lies squarely with the CJEU on this particular aspect and their answer to question 4. You'll remember I said earlier there was a very terse finding in the CJEU judgment that the statute says where a ground of invalidity applies to just some goods and services, the invalidation should only go far as those goods and services in particular. So when an application was made in bad faith, they went on, for example, by using a broad term, or too many goods and services, if we can put it that way, the invalidation is only in relation to those extra ones. And ever since, a great many commentators and judges have sagely nodded and said, well, yes, that finding was inevitable, it was obvious. I'm afraid I don't think it's either, and I think it has some effects that are plainly absurd. So consider, first of all, if you apply for a category term, and let's just say it only has 10 members so that we can make this make sense, you have intent to use only in relation to one of them, number 7. Is it really right to say you are only acting in bad faith in respect of number 7? You sought the category term in bad faith, knowing it wasn't a proper description of what you intend to do. Surely the bad faith should be in relation to the category term X, and it's X that should be invalidated. Now, that's a contentious opinion. That's not something that I think is obvious. That's what I think is the right answer. But by no means is that something that everybody should necessarily agree with. Certainly not the position under our law now. The problem that we have is the consequence, if you act in bad faith, is that you're trimmed back to the most you could ever have sought in good faith. The worst case scenario for acting in bad faith is now deliberately and forcibly aligned with the best case scenario from acting in good faith. That strikes me as absurd. If it was intended that that should be the effect, i.e. nothing, then why on earth is this in the law in the first place? And the UK actually fought quite hard at the time of framing that European law to get bad faith as a concept in. Some of the other jurisdictions who didn't have something similar were a bit suspicious, not just the UK, but the UK was seen as a ringleader at the time. So there was a fight about it. It's not just some sort of ornament to the provisions. It was there after some serious consideration. Meanwhile, until this time when you get stripped back to the most you could ever have asked for in good faith, that only happens if there's litigation. It only happens if you enforce it and someone's got enough money to fight back and counterclaim, and the court looks at it and decides. If you never enforce your mark, that doesn't mean it never does anything for you. Plenty of them sit there on the register acting as scarecrows, and I don't mean that pejoratively, this is part of the purpose of them, is that they sit on the mark and they warn people off and say, if they're accurately representing people's interests, here is where somebody has a property right, and here's a place you need not to go if you're not going to conflict with it. And so it's supposed to have a scarecrow value. It's not just meant to be a litigation device. The purpose of the register is that people can plan their behavior so as to avoid litigation if they want to. So you get a lot of value out of the bit that you've asked for in bad faith, all the while up to the moment where, which rarely happens for plenty of trademarks, you get stripped back to the most you could ever have got in the first place. And as I say, this all comes from the answer to question 4 from the CJEU. I don't think there's anything that the Supreme Court would really have done. The provisions on departing from EU law were very different, were less stringent, were less strong, I should say, at the time of our Supreme Court application than even they are now. But absent an express departure from EU law, I don't think there was ever a way that the Supreme Court could have given us what we wanted on this one. So now the rational thing to do is to apply in bad faith. You register as broad as you can. You can apply for it in bad faith and nothing bad will happen until you come to enforce. And all that you will get is the maximum you were ever entitled to, rubber stamped by an expert in a courtroom. And that only happens if it's challenged, which most trademarks won't be. And you get the positive benefit, that scarecrow value. And of course, your scarecrow value is much greater if the proprietor is a big, wealthy corporation. And people think, I'm not going to fight them. And the very last thing, one point that wasn't allowed, was excluded from the trials, is evergreening, where effectively people get to just before the time where they would have to prove use, 4.9 years we might call it, and then they just make the same application again so that they have another young mark that's not subject to it. This might be the saviour. It was excluded for boring procedural reasons we don't have time for in the SkyKick case, so it's no part of the case here. But lots of major proprietors were said to be doing it, and certainly we had alleged that Sky were doing it, but that was excluded from consideration. So it's wait and see, really, on changes of behaviour. But as for the change in the law, I look forward to seeing what you think. Thank you for listening.